The single market is one of the key points of dispute during the current Brexit negotiations, as on the one hand, Britain wants access to the single market, but on the other hand, the EU insists that access to the single market also comes with the free movement of labour as well. And there are sort of arguments on both sides of that. If we think about access to the single market first, say for example, a UK company is producing mobile phones and they can sell those cheaply in Spain. Now, obviously, the UK company benefits from this, but so also does the Spanish consumer because they get cheaper mobile phones. We can also think about the single market, though, in terms of that free movement of labour as well. Let's think about, say, a Greek worker who decides to come and live and work in the UK. Now, on the one hand, she definitely benefits because she's getting higher wages than she might do in Greece. But on the other hand, her production also means that the UK economy is benefiting as well. I think that when it comes to the single market, there's often a bit of a misrepresentation because people tend to just think that it sort of exists as it is and has come from nowhere. In fact, there was a lot of hard work that was done to get the single market up and running in the state that it is today. And there's still actually a lot of work that needs to be done by the European Union to perfect the single market. This is what we're going to look at today, and in particular the legal side of things in terms of how the EU actually harmonises the single market. And it all begins in 1986. 1986 is important because it was the signing of the Single European Act, and many of the provisions of that piece of legislation are now featured in the Treaty on the Functioning of the European Union. And so today we're going to be focusing on Articles 26, 27, 114, and to a much lesser extent, Article 115 as well. But let's start with Article 26, and Article 26.1 dropped the deadline for completing the internal market. Originally, a deadline was set of the end of 1992, but there was an understanding in the Single European Act that the completion of the single market is actually an ongoing process, and so setting a deadline for it is not actually that useful. 26.2 defines the single market as an area without internal frontiers in which the free movement of goods, persons, services and capital is ensured. 26.3 allows for the Commission to take this forward by making proposals or recommendations to the Council, and so that's the sort of practicality of how that would work. Meanwhile, Article 27 says that when the Commission is actually doing this, they can take into account the effort required by national economies. So for some, the integration into the single market is going to be much more difficult, perhaps in relation to particular products, which the national economy is not familiar with. You can imagine this being a sort of significant issue when a lot of the Eastern European countries join the EU after the fall of communism. And so within this power as well, in Article 27, the Commission can allow for derogations in certain contexts. In other words, certain countries might not have to apply the rules for a period of time so that they can actually catch up. The main provision we're going to be looking at today, though, is Article 114, and this is actually the sort of power of the EU to provide for the harmonisation of the single market. The reason that we're not talking about Article 115, which has a similar overall effect, is that Article 115 is a lot more difficult for the European Union to use. In the first instance, it requires unanimity. In other words, all of the countries have to agree to the actual provision. And secondly, it only allows for directives. Article 114, on the other hand, uses the ordinary legislative procedure within the EU, and it also allows for regulations as well as directives. And so we can already see that Article 114 is much more flexible than Article 115. And so that's why we're going to be talking about that mostly today. Despite this flexibility, there are some limitations there. So the tobacco advertising case from 2000 is perhaps the most famous example of this. And the European Court of Justice basically said that while you can do things within the context of Article 114, This is limited to the extent that the objective still has to relate to the harmonisation of the single market. So as long as that is clearly the objective, then you're fine. But if the EU moves away from that objective and starts to go into other areas, then that will not be allowed. However, in the tobacco advertising case of 2006, the European Court of Justice sort of looked at a similar directive, but they said that here now the objective was the harmonisation of the single market, and so the tobacco advertisers actually lost that case, and the directive was allowed to stand as it was made under Article 114. So it is still very flexible, but there are limitations at the far end of that. The other point to make is that in Article 114 there are a number of qualifications to how this power can be used by the European Union. 1142 says that it cannot apply to fiscal provisions, free movement of people and employment rights. Meanwhile, 1143 says that it for health, safety, environmental and consumer protection, the baseline on which the EU works is a high level of protection based on the latest scientific research. However, the main qualification to Article 114 actually comes from the following subparagraphs, which is Articles 114.4 through to 9. And this is important because it potentially allows member states themselves to go against the harmonising measure. This is rarely used, however, and the power that the member states have is subject to considerable restraints. And if you want to sort of see this in a bit more detail, then those treaty articles do set it out perfectly, but I'm just going to give a quick summary here. So in subparagraph 4, we have member states' concern has to relate to the environment, the working environment, or the exceptions that we've previously seen in Article 36, and that's particularly used in the context of free movement of goods, but it can be used here, and this would be things like public health or national security concerns, some of the big concerns that individual member states might have. Now, this is not for new domestic legislation within a member state, it's only for existing legislation within a member state. For new legislation, we instead need to look at paragraph 5, and this is for new national measures, but only for the environment or the working environment. So Article 36 isn't mentioned in this particular context. Meanwhile, the new provision has to be specifically related to that member state, and it has to be based on new scientific evidence. In other words, the member state is not able to move away from the harmonising measure simply because it doesn't like it. It has to do so for scientific reasons and for reasons that are particularly related to the unique circumstances of that country. The other constraint that we have in relation to these subparagraphs is that the burden of proof is on the member state, and the Commission and European Court of Justice will always take a narrow approach to derogations from the treaty. Remember that the aim here is to try and harmonise the single market, and so any country that is working against that will have their measure or domestic legislation scrutinised very carefully. Before we finish, one of the other qualifications that I forgot to mention comes from Article 114.10, and this allows member states to take their own action, albeit on a temporary basis, against a harmonising measure, but only when there has been an issue that's arisen in relation to Article 36. So the things like public health or national security, some of the very serious things. So again, while this is a qualification to Article 114, it can only really be used in quite limited circumstances. So that kind of completes where we are on the single market and how the EU actually harmonises the single market. But in terms of the practicalities, what have they actually done about this? Well, mostly this is based on the idea of mutual recognition. In other words, if the UK recognises that a certain product is safe, then all of the other member states of the EU should recognise it as safe as well. Beyond that, the EU has certain ideas in terms of what standards they should actually set for a particular product, or more likely a set of products, such as toys, for example. On the one hand, they can set a minimum standard, and allow some of the bodies within the European Union to actually set standards for themselves on an advisory level, or if the EU is particularly worried about safety or public health, then they might want to set quite high standards that are exacting on the companies that are affected. So that's how they can approach that. But in terms of where the single market is nowadays, there is a bit of concern about sort of where the single market is going, and that goes beyond the Brexit negotiations. A few years ago, Mario Monti, who was one of the sort of senior people within the EU, put out a paper about some of his particular concerns. And he was worried that the single market may no longer have political or social support. In other words, people are moving away from globalization, and we saw this with things like the Occupy movement and some of the recent election results across the European Union, that people are just not as enthusiastic about the single market anymore. On the second level, we also have the idea about who should the single market be protecting. Many people see it as benefiting companies rather than the actual consumers themselves. And finally, there's also other concerns about the single market in terms of, are people still considering the single market as an ongoing process? Many people, as I mentioned at the start, feel that it is something that has already been completed by the EU and doesn't need any more work. And this is a slightly worrying thing because, as we said in Article 26, this is an ongoing process. Well, thank you very much for watching this video. It's gone on a little longer than I thought it would, but never mind. If you did enjoy it, make sure to leave a like, and if you've got any questions, comment below. Also, subscribe for more videos in the future. I look forward to speaking to you again soon, but for now, bye!